Hi, hello, how are you all? Welcome to my channel Law Made Simple with me Vidya Reddy. Today in the series of labor law episodes, let us move to the new topic Industrial Dispute Act 1947. Let us learn when does an individual dispute becomes an industrial dispute. We have certain definitions. When these definitions comply, then we can say the individual dispute is nothing but an industrial dispute. We have certain definitions. Let us look into that. Industrial Dispute Act, Section 2K. In this section, we can say a dispute or difference between employers and employers, or between employers and workmen, or between workmen and workmen, which is connected with the employment or non-employment, or the terms of the employment, or with the conditions of labor of any person. So, we have some parties to the dispute. What are the parties? Employers and workmen, employers and employers, workmen and workmen. So, there is also another definition of Trade Disputes Act. The Trade Disputes Act 1926 says, in the Trade Unions Act 1926, the section 2G defines trade dispute. What does it define? It is a dispute between employers and workmen, or between workmen and workmen, or between employers and employers, which is connected with the employment or non-employment, or the terms of the employment, or the conditions of labor of any person and workman. Means all persons employed in the trade or industry, whether or not in the employment of the employer with whom the trade dispute arises, is nothing but a trade dispute. Here the definition is so simple. We can say that parties to the dispute are employers and workmen, employers and employers, workmen and workmen. And it should be related either to the employment or to the non-employment, either to the working conditions or to the conditions of the labor. So this whether that workman is under one employer or any other employer, it is a trade dispute. So, the definition of the trade dispute in Trade Unions Act 1927 and the Industrial Dispute Act 1947, the section 2K, both are matching with each other. So, thus the individual dispute becomes an industrial dispute if they both comply with each other. So, let us discuss what are the constituents or what are the ingredients of the industrial dispute. The dispute must relate to an industry as defined in section 2J of the Act. Which Act? Industrial Dispute Act 1947. There must be a dispute or difference. Who are the parties? Employers and employers, employers and workmen, workmen and workmen. Again, with what is the subject matter of the dispute? Whether it is employment or non-employment, what are the terms of the employment, whether it is related to the condition of the labor of any person. And an individual dispute, to fall within the definition of industrial dispute, it must be sponsored by the trade union. So we have certain case laws. Let us look into that. Chandrakant, Tukaram, Nikam and others versus Municipal Corporation of Ahmedabad and another. Here, it was held by the Supreme Court that the jurisdiction of civil court was impliedly barred in cases of the dismissal or removal from the service. The appropriate form for such relief was one constituted under Industrial Dispute Act 1947. So, here in this case, it is said that the Supreme Court said that the civil court is not enough to take the cases or the dismissal or removal of the service of the employers, and it should have any dispute relating to the industrial dispute, then it can consider it. Again, another case in Jadhav JH versus Forbes Gobak Limited. In this case, it was held that the dispute relating to a single workman may be an industrial dispute if either it is espoused by the union or a number of workmen, irrespective to the reason the union espousing the cause of the workman was not the majority of the union. So, an individual dispute becomes industrial dispute when it is supported by the trade union. Even one worker, if he has a dispute and that a single workman is supported or espoused by the trade union, then it becomes a industrial dispute. So, let us now look when does an individual dispute become industrial dispute. What are the key ingredients? Before the insertion of the Section 2A of the Industrial Dispute Act 1947, an individual dispute could not be an industrial dispute, but it could become one if it is supported by the trade union or some workmen. The Supreme Court and majority of the industrial tribunals held that a dispute raised by a dismissed employee would not be treated as an industrial dispute unless it is supported by a trade union or by a body or section of the workmen. So here it is clear, a dismissed employee cannot raise this individual dispute to become an industrial dispute unless it is supported by trade union. So the individual dispute to be declared as an industrial dispute, it should have a body of workmen, which is nothing but trade union, or a considerable number of workmen to have a common cause with the individual workman. So the dispute should be sponsored by the trade union or by considerable section of them before the date of the reference. So we have again some case laws. The Bombay Union of Journalists versus the trade union. A person working in Hindu of Madras, he was terminated for claiming that he is a full-time employee. The Bombay Union of Journalists raised this dispute. It was found that there were only 10 employees, of which 7 were in the administrative side and only 3 in the journalism side. Of these 3, only 2 were the members of the union. Therefore, the Supreme Court held that in the union only 2 people are there. Now, the journalists of the Bombay Union cannot compete to raise the dispute to be a industrial dispute. Even if he had raised it, it could not become an industrial dispute. This will only be an individual dispute. In another case law, the workmen of Indian Express Newspaper Limited versus Management Indian Express Newspaper. Here, again it was between the management and the workmen. A dispute relating to 2 workmen of Indian Express Newspaper Limited was espoused by the Delhi Union of Journalists, which is an outside union. About 25% of the working journalists of the Indian Express were members of that union, but they have no union of journalists of the Indian Express. It was held that the Delhi Union of Journalists could have been said to have representative character with the working journalists employed in Indian Express, and the dispute was transformed to a industrial dispute. Here, the Indian Express newspaper, they don't have their own trade union, but these people who are working in the Indian Express newspaper, the 25% of the working journalists are the part of which union? Delhi Union of Journalists. So the Delhi Union of Journalists is now the trade union which are supporting the Indian Express workmen. The Indian Express newspaper workmen, now the individual dispute has become industrial dispute. So overall, to become an industrial dispute to become an individual dispute to become an industrial dispute, it must be either sponsored by the trade union, or the trade union must be sponsored by the workmen, or it must comply the requirements of Section 2A of the Industrial Dispute Act 1947.